All right, welcome to video recording for the exam review for Management 254. I apologize, I'm at a judicial conference for today's class, and so it's a mandatory conference, otherwise I would be here. I will be here to proctor your exam, and if you have any questions or concerns, my email and my cell phone number are included on the syllabus. I will be checking my emails and always looking for an opportunity to walk out of a boring presentation at a judicial conference because of a question from a student who's calling me on the cell phone. So you won't offend me in any way if you reach out and have questions. The exam will be 50 questions. It will be multiple choice and I think relatively fair, but the exam review will be helpful for you, I think, in readying yourself for the exam. I'm going to go through some but not all of the things that we covered in class in the various chapters, and so we'll get started with that now. We started out talking about the sources of the law, and of course when we're talking about the law here in Business Law 1 at Purdue, we are speaking mostly about U.S. law, almost exclusively about U.S. law. And so the baseline that we think about are the state and federal constitutions. The state and federal constitutions lay out the structure of the government, and they also establish kind of a baseline. When people talk about their constitutional rights, what they're really speaking about is their baseline rights. These are the rights that governments are prevented from taking away, whether that be governments taking things away by passing laws, or governments taking away things by police action or court action or something like that. In addition to the Constitution, which again is sort of the bedrock of our legal system, we have state and federal statutes and local ordinances. These are legislation. These are passed by federal, state, and local legislatures elected democratically. So on the federal level, of course, we're speaking of the United States Congress, being the House of Representatives and the United States Senate. If we moved into a state level, at least here in Indiana, that would be the General Assembly of the state of Indiana. And if we want to move down even to a smaller unit, we would talk about the West Lafayette City Council, for example, that passes ordinances that affect all of us. Another source of the law, in addition to the Constitution, the statutes that are passed by legislatures, are court cases, case law it's called. The courts are charged under the Constitution with the interpretation of the law, but their interpretation of the law, as passed by the various state legislatures, does in and of itself become law. It is part of the common law, as established all the way back in England, but moving on to the Americas. And under the common law, of course, the doctrine that you would want to remember is stare decisis, which means that the lower courts are bound to follow the decisions of the higher courts. So if you have a decision of the U.S. Supreme Court, that's the highest court in the land. That has the force of law. If you had a lower federal court or a local court here in the state of Indiana, and they were presented with an issue that had been decided by the United States Supreme Court, then they would be bound to follow that as the law. And of course that would apply all the way up the chain. And so if I, as a trial court judge, am dealing with an issue that has been decided by an Indiana State Appellate Court panel, I am bound as a trial court judge, sort of the lowest figure in the system, to follow that decision. In addition to those three things, we also have administrative law. We will talk a little bit later in this review, and we have previously talked in class about administrative agencies, but administrative agencies and the rules that they make do have the same force as a statute. And there can be civil and criminal penalties provided for people that do not follow rules made by administrative agencies. Another source of the law is private law. What do we mean by private law? If we have a contract with our neighbor, for example, or someone we do business with and we violate that contract, we can be hailed into court, we can be sued if our neighbor or our business partner breaks the terms of a contract. We can bring them into court and sue them, and so they have the force of law, at least as it relates to the parties to that particular contract. Covenants and restrictions. Covenants and restrictions apply generally in the law of property, real property, meaning real estate. There are covenants and restrictions that limit the things that you can do with your property, and those have the force of law. Industry standards may also have the force of law. I am regulated as a member of the Indiana Bar because I am an attorney, and as such I'm bound to follow the requirements and the standards that are set forth by the profession. And as a judge, I have requirements and standards that I'm required to follow that would be in addition to those standards that I'm required to follow as an attorney. We talked a little bit about the common law. The common law is the law of cases that were decided by courts, but in addition to, as I mentioned, the U.S. courts, common law doctrines come all the way from the beginning of time to the United States. So prohibitions against things like stealing and not paying on contracts and things like that, those weren't concepts that were invented here in the United States. They existed for centuries before that. And so all of those decisions and all of those standards and all those concepts come to us from the common law. In addition to that, other sources of the law, treaties. Treaties with foreign nations can have the force of law, do have the force of law, and would potentially impact citizens of the United States. Executive orders is something that we hear about, it seems like, in the news, particularly right before a president is getting ready to leave office or right after a president takes office. Those are things that the president is empowered to do under the president's authority that do not require action of Congress or of a legislative body in the state. That would be an act of the governor, of course, and I suppose here locally it would be an act of the mayor. And there's usually a little bit of controversy surrounding those as to whether those executive orders have gone further than the executive's authority, and those are frequently challenged in court. The most recent example that was in the news probably in the last year or so would have been the attempt by the president to restrict travel or immigration to and from certain countries, and that was not upheld in the court as well. International law can have the authority of law as well and impact individuals here in the United States, particularly if the activities of those individuals involve other countries and they are standards of international law that have been adopted by the United States. The difficulty with international law is that a lot of the treaties and conventions and things like that only have the force of law among the countries who have adopted them, and in many cases the United States has not been one of those countries who have ratified these treaties or decided to participate in these conventions. All right. So now we move from sources of the law to the structure of the legal system. We'll start with the one that I probably know the most about here, is courts, and we'll talk a little bit about how courts work and also about alternative dispute resolution, which is a way of resolving things without going to court. A court is simply a tribunal established by the government to hear and decide matters properly brought before it. So you have to have jurisdiction. I'm in my court not empowered to hear cases regarding federal bankruptcy claims and things like that. So there's a court for everything. So the first thing is you have to have the right court or get into the right court. All levels of governments have their courts. The courts are generally established by the constitutions of that particular government. So at the federal level, of course, the Constitution establishes the Supreme Court. In the state of Indiana, the Constitution establishes the Supreme Court, the Courts of Appeals, and the circuit courts. There also can be statutorily created courts. I work in a statutorily created court where the legislature decides that there need to be another court here or there. And so courts can be created by Constitution or by legislation at the federal, the state, and at the local and municipal level. There are town and city courts still in Indiana. They are dwindling in their number, but there are a few, and they, generally speaking, only handle ordinance violations, small matters, speeding within the city limits, and those kind of things. So we have a court case. Who are the parties to the court case? This is something that would be good to know for the exam. The party that initiates the case, brings the case in a civil case, and remember, we talk later in this presentation, but we've already spoken about the distinction between a civil and a criminal case. Civil cases being about money, criminal cases being more about potentially loss of liberty because of some violation of state statute. But in a civil case, the person that brings the case, or the entity, can be a corporation, business, government agency, is called the plaintiff or the petitioner. The plaintiff or the petitioner. In a criminal case, the plaintiff or the initiating party is always the government. It may be the U.S. government. If it's a federal violation, can be the state of Indiana. Generally speaking, municipalities don't maintain much criminal jurisdiction, but they can as well. Responding party in either a civil or a criminal case is called the defendant or the respondent. So again, initiating party, plaintiff or petitioner, civil, it's the government, state, or the federal government generally in a criminal case, and the responding party would be the defendant or the respondent. So what are these pleadings that get things started? The initiating pleadings in a civil case is called a complaint or petition. Complaint or petition. You file a complaint because you believe someone's breached a contract. You file a complaint because someone sold you something that you don't believe met the specifications. Someone has damaged your property in some way, damaged your body through some kind of personal injury. You would file something called a complaint. In a criminal case, the initiating pleading is called the information or the charge. So you say someone has been charged with robbery. Someone has been charged with murder. That is the reason for that. The responsive pleadings then, and in some cases a responsive pleading is required. Most cases a responsive pleading is required, or there is an assumption that you are saying yes, what they've alleged is correct, and the initiating party could then get what's called a default judgment against you. And so in most cases you have to respond if you've been called into court on a suit. In a civil case, the response is generally speaking called the answer. So a complaint and then an answer, and most answers are denials, of course. Another thing that you can file, though, instead of an answer or in addition to an answer, is what's called a motion to dismiss or demurrer. And that says, essentially, even if everything that they say in their complaint against me is true, I don't owe them a thing. It is against the law. What they're suggesting is contrary to law, and so I'm not denying that what they say is true, which is what you might do through an answer. I'm saying that everything that they are saying is true, but even if it is, there is no recovery against me. Another thing that you have to do generally in civil cases is there's a rule that if you have any claims against one another and someone sues you, you are bound to sue them back for any claims that you have against them. The idea is if we've got claims against one another, let's get them all thrown together and let's resolve them all at once. Let's not have person A suing person B and person B not mentioning that person A owes them money and then waiting a year and having another lawsuit. So if you're sued and they owe you, or they've damaged you in some way and you've got some claim against them, particularly if it's in any way related to the claim that has been filed, you are bound by the law to raise that claim in connection with your answer or your motion to dismiss. And if you fail to do that, you may be barred from ever raising that claim again. And generally, the thing that is raised is called a counterclaim. That is a claim back against the plaintiff by the defendant. You may have also what's called a cross claim. There may be other parties that are involved in the transaction or the situation that are related, and so you may, even though that person's not sued you, so they're not a plaintiff to you as a defendant, you may sue some third party and bring them into the litigation, or maybe they're already in the litigation as a co-defendant. They've also been sued by the plaintiff. You have an obligation then to make a claim against them, or you would be again barred from ever making that claim in the future. In a criminal case, the responsive pleading is called a plea, or in some cases you may file a motion to dismiss. Unlike a civil case where this would be a written document or nowadays electronic document, in an answer or a motion to dismiss. That is generally done in open court. Orally, the person enters a plea of not guilty or a plea of guilty and then takes it from there. A motion to dismiss might be based on the fact that you believe that the arrest was invalid in some way, that the evidence will be or should be suppressed. So that would be another potential response. Normally, though, you do enter that plea of not guilty in connection with that motion to dismiss and not in lieu of the motion to dismiss. So we have the court case has been initiated. It is an operating case within the court. The next step, generally speaking, is what's called the discovery process. The discovery process helps the parties determine what are the facts and the issues before they come to court. Normally, when you file a claim or respond to a claim, you don't know all the facts. And it would be unfair to simply have the trial on the first day that everybody is in court. There are some exceptions to that, parking tickets, things like that. You know, there's not a lot of discovery that needs to be done. But in most cases, both parties want some opportunity to do some investigation to find out what the facts are and to kind of narrow the issues a little bit. So how do we do that? One way we do that is through a deposition. Depositions are sworn statements. Depositions can be taken of the parties or of anyone else related to the case. So in a civil case, you might have someone who was a bystander that saw what happened. They can be subpoenaed in, required to submit themselves to a deposition. In civil cases, people can be required to submit to depositions. Now, of course, in a criminal case, the defendant cannot be required to submit themselves to a deposition because they have the right to remain silent. And so that's one of the exceptions to the use of depositions. You think of depositions sometimes in the context of criminal cases. We might think of, for example, the Bill Cosby situation where he was criminally charged relating to some allegations that he had drugged women and committed rape. And there were depositions. Well, the reason there were depositions is because those depositions were taken in context of a civil case, a case that had been brought by an alleged victim for money damages, and those were, of course, related to the criminal case. If you are in a civil case and you are asked questions under oath about something that may tend to incriminate you, you do have the right to claim your Fifth Amendment right against self-incrimination and refuse to answer. Normally, the remedy to that situation would then be that you would have a judge or the state step in and say, you know, we agree that there'll be immunity or something like that, and then the person could then be compelled to answer under a grant of immunity. Another way that we get information about the facts and the issues is through written interrogatories. It's just a list of 20 or 50 or 100 questions. Depending on the state that you're in, there's normally a limitation on the number of questions that you can ask, and so lawyers always try to get around that by making 5 or 6 subparts to every question. But they are questions that are sent from one party to the other party, hopefully with the assistance of counsel, if they're smart, will sit down and draft the answers to those, and then those are answered under oath. And so if you lie in any of those responses, then that's something that could be used against you later. That would technically be the crime of perjury. And really, in all of these situations, whether they be depositions or interrogatories, the purpose of this is to nail the person down on their testimony so that if at trial their testimony is different, that you could point out before the judge or the jury that they'd previously testified differently than that, and use that as a way to impeach the credibility of this witness that was not favorable to your situation. Requests for production, again, another tool, both in a criminal and a civil case. The plaintiff or the defendant can ask for documents or items that may exist, and the person that receives that request is bound to comply. So you may get a request in a case for your tax returns for the last several years, or bank records, or wage and income statement information, things like that. You are bound to produce that, and the state or the federal government can get those either from the defendant or directly from a third party. So if you're alleged to have committed tax evasion or something like that, the government can go directly to your bank and through the use of what's called a subpoena ducis tecum, which is the same as a request for production, get those documents directly from them, and they are bound to produce them. Another discovery tool is what's called a request for admission of facts. That's a trap, frankly, that some lawyers use. Is if you are in a lawsuit and someone sends you a document requesting that you admit certain facts, and they list all these facts, and it's normally all the facts that would make their claim absolutely true, and if you don't answer those within the time that you're supposed to answer them, they are deemed to be true. So if you've misplaced something or not been organized and not gotten back during the time period, that can be a trap for someone in a civil case. So discovery has been completed. We now would move on to the trial phase. The beginning of a trial, if it is a jury trial, sometimes trials are to the judge. The beginning of the trial would be what's called jury selection, known as voir dire. After voir dire, and voir dire normally takes a long time. The lawyers get to ask questions to all the jurors. They get a certain number of opportunities to strike jurors without giving any reason at all. There are rules against race-based striking of jurors, but generally speaking, it's pretty free. You have a certain number of people you can throw off for no reason at all. Obviously, if the person shows up as biased in some way or has knowledge of the facts of the case, you can throw them off without using up your challenges that you have for no reason. So jury selection can be very lengthy. After jury selection, we have opening statements. That's where the lawyers say what they believe is going to happen in the case. They're not evidence. They're only a roadmap of what the lawyers believe that the evidence will be. That is followed by the presentation of evidence through witness testimony and exhibits. And if any of you have been in a court case or been a juror or watched a trial on television, a real trial, not Judge Judy, the general process is that the lawyers will call a witness, they'll get the evidence that they want in, and then the other side gets an opportunity to ask that witness questions about their testimony. Also under oath, that's the right of cross-examination. And then if the lawyer that originally called the witness wants to talk some more, then they have redirect. And then if the other lawyer wants to talk some more, they have recross. And they'll go back and forth until they've run out of oxygen in the room. And then the poor witness finally does get to get off the witness stand. Exhibits, there are rules governing the admissibility of exhibits. Exhibits can be documents. Exhibits can be, bloody gloves, guns, all kinds of things can be exhibits. They are required to be admitted according to the rules of evidence, which the judge makes decisions on. Then those would normally be passed to the jury and even sent back to the jury room to be examined by jurors at their request. Motion for directed verdict, after all the evidence comes in, normally the party that doesn't have the burden of proof, so in the criminal context that would be the defendant, well, in the civil context it would be the defendant too. They say, Judge, we've seen all the evidence at this point, and even with everything that's been put in, there's no possible way that they've met their burden to show either that I'm guilty of this crime or that I owe this money in a civil case or something like that. And so that's a frequent motion that's made at the close of evidence, sometimes granted, sometimes not. If it's granted, the case is over. If it's not, then we move on to closing argument. That's where both lawyers get an opportunity to characterize the evidence and try to persuade the jury to a particular verdict. Those arguments are not evidence, of course. However, there is, generally speaking, broad leeway of the lawyers to make certain arguments, although cases can be reversed if lawyers do cross the line. Particularly prosecutors in some cases may vouch for witnesses' credibility or something like that, which is inappropriate, and it can result in a case being overturned. Following closing arguments, the juries are instructed on the law, sent back to the jury room for deliberations. If it's not a jury trial, then the judge sometimes will make a decision right there. Sometimes the judge will take it under advisement. But that's the decision phase. And then, of course, when the decision is made either by the judge or the jury, there would be a verdict that would be read in open court in a criminal case, or in a civil case, a judgment would be rendered by the filing of a document or an electronic document nowadays. After the verdict or the judgment, the party that is not satisfied with that, the losing party generally speaking, may file a motion for judgment notwithstanding the verdict, saying, okay, we've got the verdict, but it's so contrary to the facts and the law that it should be thrown out anyway. Those aren't very frequently successful, but it is something that occasionally does get filed. So we've had our trial. What happens now? Well, in a civil case, the party that has won, in a civil case is about money generally speaking, they will try to recover their costs and damages. Mostly that will not include attorney's fees. The English rule is that the losing party pays the other party's attorney's fees. That did not make it across the Atlantic Ocean into the American system. So generally speaking, even if you win the case, you're responsible for your own attorney's fees. You'll then want to try to collect the judgment that you've got against the other party. That can be dicey, particularly if that party does not have significant assets. Some of the things that we try, garnishment of wages is the most common way. If someone has employment, you can get an order that their wages be garnished. That's limited, however, to a certain amount. You can't take all of their wages. It's a statutorily set limit, and if there are other garnishments that have priority over your garnishment, then you have to wait until those have been satisfied before yours will be satisfied in any way. If you can find that the other party has assets or accounts, you may try to seize those and collect by cashing those in. An appeal is another thing that may happen after the trial. In all cases, there is an opportunity to appeal a trial court's verdict in a criminal case or in a civil case to a higher court. That would be the Court of Appeals in the state and federal system. And then if you don't get the result that you want there, then up to the Supreme Court. And if you're in a state level and you believe that the state Supreme Court has done something that isn't appropriate and it impacts a federal issue, you can even go up to the U.S. Supreme Court. So there are lots of opportunities to appeal. There are deadlines for filing notice of appeal. If you miss that deadline, then you've lost your right to appeal. That deadline usually is 30 days, but isn't always 30 days, and I'm not giving you legal advice. So if you ever are in this situation, make sure to have counsel and to consult those statutes. In a criminal case, after the trial, there's a sentencing hearing. Criminal cases are different than civil cases. They don't just involve money. They can. There can be criminal fines and restitution and things like that. However, potentially also loss of liberty or even loss of life in the case of a death penalty case. So sentencing would come next. And then, as I mentioned, appeal. Just like in civil cases, there is an absolute right to appeal. In a criminal case, incidentally, we all know that we have a right to be represented by an attorney, and if we can't afford an attorney, then we have an attorney appointed for us at no expense. That's a right that actually was created in the 70s, did not exist right at the beginning of the Constitution. The right to have an attorney always existed, but not the right to have it paid for by the government. In the way that the law has developed now, not only do you have a right to have an attorney at the trial level if you can't afford one paid for by the government, you also have a right to have an attorney paid for by the government at the first appeal of right. So at your first appeal, now subsequent appeals, post-conviction relief, you do not have a right to have free counsel for those proceedings. As I mentioned then, post-conviction relief is something in addition to an appeal. So you may lose the case, be found guilty, sentenced, file an appeal, lose the appeal. If there are constitutional issues raised, or let's say there's DNA evidence that exonerates you or something like that, you're not completely out of options, even if you've lost at the trial and lost at the appellate level, because there is this right of post-conviction relief where you can go back in, you can allege that your lawyer did a bad job either at trial or at appeal. You can allege newly discovered evidence that shows that you're innocent and things like that. So there are some opportunities to get out of jail if you are wrongfully convicted. All right, well, that's enough of the regular court system. Let's move on to alternative dispute resolution, also known as ADR. The most common form of ADR is called arbitration. Arbitration is a situation where the arbitrator acts as a judge or jury. The idea is that it's a little less formal than a court trial, theoretically less expensive. The rules of evidence that apply in a court trial don't necessarily apply in an arbitration proceeding, and so it's quicker, cheaper, and therefore preferred in some situations to a court trial. Arbitration may be binding, and it can be binding. Usually, however, it's only binding if the parties have agreed in advance. One area where you may have agreed in advance and not known about it is if you sign a contract with your stockbroker or something like that to manage an account. If you look in the fine print there in the contract, you may see something where it says that you agree that if there's any dispute between you, that you will go to binding arbitration, and the ruling of that arbitrator will be final. However, in any other cases, the parties, if they just agree to go to arbitration, that arbitration generally is not binding. That doesn't mean there's no value to it. All that means is that if after the arbitration is over, one party doesn't like the result, they can say, this result is not going to be what we're going to have, we're going to go ahead and go to court. But even in that situation, it still does have some value theoretically, because it does help the parties narrow the issues and maybe give them a more realistic idea of what the case is worth or what the likely outcome may be. Mediation is another form of alternative dispute resolution. Under mediation, the mediator acts as a messenger between the parties. So you normally have the parties in opposite rooms, and the mediator will go to the first party and say, what's your offer? Take that to the other party, get the counter offer, go back and forth, and hopefully in the course of doing this can narrow the issues, or in some cases eliminate the issues. Sometimes cases are completely resolved through mediation. Sometimes only certain issues are resolved through mediation, but that does allow the court then to focus on the issues that are truly contested between the parties. Med-arb is a blend of arbitration and mediation, probably not on your exam. And then there are other ways that we may resolve disputes short of going to court. Association tribunals. So, for example, the Disciplinary Commission of the Bar Association is a tribunal that would be responsible for handling allegations of attorney misconduct or something like that. Summary trials, parties can agree that they're just not going to go to court, that they're going to allow some referee or some other party to resolve the dispute and agree to be bound by that. So those are other ways that we may resolve a dispute short of going to court. But arbitration and mediation would be the main two there. All right, we'll move on to our discussion of ethics that we had. Ethics is a little bit of a slippery topic, of course. Kind of depends on your background and your particular view of the world to a certain extent. However, some that we might want to know for the exam is the positive law. So if someone followed a positive law, ethical regime, ethical view of the world, what that person would say is if it's legal, it's ethical. If it's legal, it's ethical. Anything legal is also ethical and moral. Now that's obviously troubling, particularly since there are some things that through the course of history have been legal that everyone who has any level of common sense would now agree are not and have never been moral. So for example, slavery. It's hard to defend the positive law view of slavery because at one point slavery was quote-unquote legal in the United States and other countries around the world. Some folks follow what's called a natural law theory, and under a natural law theory, this applies a higher standard. It's almost kind of a religious ethos here. You know, there are just certain things that are just right. And so certain acts, while they may be legal, would nevertheless be immoral and unethical. And so that would obviously apply in a situation like slavery, where even though at some point it was considered to be legal, it would be unethical because we would have a higher standard. Some others that you may want to be familiar with, there's Kant, and I took philosophy, a couple philosophy classes in college, just enough to screw me up for the rest of my life. But what Kant would say is act in a way that you would want or expect others to act if it were the universal will, and treat others as an end and not a means to an end. So if what you're about to do is something that you would agree should just be applied to everyone, this should be a universal way that anyone would act under these circumstances, and you'd be willing to make that be a rule, then that's okay. Then that would be ethical, and again, treat others as an end and not a means to an end. Contractarian theory says that we are, by being in a society, we agree to be bound by certain rules that keep the trains running on time and the banks open and the streets clean and safe, and therefore it is unethical to do anything that would break that social contract that we have with our neighbors and with the society that we live in. Rights theory, and these overlap. You know, things can be right and wrong under all of these for similar reasons. So rights theory, people would say that there are just certain inalienable rights, and therefore anything that government would do or an individual would do that would take those rights away, like to life, like right to association, things like that, would be unethical by definition. Ethical egoism, that's Ayn Rand, which is everyone should just act on their own self-interest, and if everyone is just out there acting in their own self-interest, actually the net gain benefit for society as a whole is better, because that's the way people should be acting. I can think of a lot of sort of negative impacts of that, but at any rate, it's a popular theory. Utilitarianism, that is, you make a decision about whether something's right or wrong, depending upon, under that situation, whether what creates the most good for the most number of people. So that also can have some troubling potential impacts. You know, if you have a situation where you have the ability to end war forever, but as a cost of that, you have to make a decision that's going to cause a child to be tortured or killed in some horrible way. How could that possibly be the right thing to do? But under a utilitarian theory, I suppose, that would just be, you know, the goods of the many outweigh or the needs of the many outweigh the needs of the few. So anyway, a moral relativist doesn't really have any particular ethical theory and just sort of makes the decisions at the time based on the circumstances. So a little bit like a utilitarian theory in that situation. All right, let's move on to a little bit more detailed conversation about the U.S. Constitution. We talked about the U.S. Constitution in the context of being a source of the law, but we're going to delve into it a little bit deeper here. The U.S. Constitution is actually something that came from the states. That's forgotten in a lot of ways, particularly because the federal government has just become so dominant and so huge. But the United States Constitution was ratified by the states. It only contains the rights and the powers that the states chose to give to the federal government at the time. One of the things that the federal Constitution does is it establishes the structure of the government. It sets out the legislative, the executive, and the judicial branch. We've talked about that a little bit. Legislative make the laws, the executive enforces the laws, and the judicial interprets the laws. So those are the branches of government established by the Constitution. As I mentioned, delegated powers. These are powers in the Constitution that are delegated to the federal government by the states. The states are the source of the federal government's powers. Examples of delegated powers, and these are things that only the federal government does. Regulation of interstate commerce or international trade. Well, that makes sense. We don't want to have New York and California and Indiana and Texas all having their own particular regulatory structure with regard to interstate commerce between the states or commerce with foreign nations, because what a mess would that be? And then you'd have all of the states competing against one another to sort of be the least regulated and things like that. Coining money, we don't really want to have 50 different currencies. You don't want to have to go to a currency exchange when you go to Ohio and get Ohio money for Indiana money. National defense, obviously, is something that needs to be done on a national level. And declaring war. We don't want, you know, Louisiana getting mad at Cuba and declaring war, and then all the rest of us are sort of stuck with the consequences of that. So those are the delegated powers. Most of those make sense, at least at that level. And then there are powers that both the state and the federal government under the Constitution share and can exercise at the same time. The most common one of those, of course, is the power to tax. In Indiana and at the federal level, you would pay both a state and a federal tax, and in some cases a local tax. You may have a city tax as well, depending on where you live. Federal supremacy. I mentioned that the federal government has become the dominant government, even though it does derive its powers from the state. And one of the reasons for that is court decisions that have said that if there is an area where the federal government has legislated, has acted, has exercised legitimately its power, then the states are prevented from going in and exercising their power in that area. The theory is that we don't want to have differing sets of contrary legislation or rules that are applying and making it difficult for people to do business or live their life because they've got to meet competing and in some cases standards that might even be in direct conflict with one another. Another concept that goes along with federal supremacy is that if there is an area that has been reserved to the federal government to regulate and the federal government, for whatever reason, has decided not to or has failed to act, that silence of Congress does not mean that the states are then empowered to step in and fill that void. The theory being that the reason that Congress may have acted is they've decided that not acting is a good thing. And similar to that would be deregulation, something that the federal government has previously regulated through a legitimate exercise of their power. If they then deregulate that, they make a decision that they don't want regulations relating to that particular thing, the states again are not empowered to go in and fill that void by enacting their own regulations. So if it's a federal matter and the federal government has acted on it, the states are to stay out. And if it's a federal matter, no matter what, then the lack of action or the reversal of action does not in some way give rise to a state's right to go in and regulate. All right, the power to regulate commerce. The power to regulate commerce comes through the Commerce Clause. The Commerce Clause states that the U.S. Congress shall have the power to regulate commerce with foreign nations among the several states and with Indian tribes. That's fairly broad language, and it has been interpreted broadly throughout the years. And the Commerce Clause, because if you think about it, if a transaction in any way crosses state lines, then clearly the Commerce Clause is enacted. Or if there's a contract between people of different states. Or let's say that they pick up the telephone and the telephones are regulated by the federal government and the wires for the telephones cross different states. So all of these broad brush sort of concepts have come out and have caused the expansion of the federal government through the theory that it's something that involves the commerce between the several states, basically. So it's become a general welfare power and has been used as such. However, there has been a little bit of a reversal in recent years about that, a little bit of a pushback. There was the Morrison case that's in your book. You don't have to know individual cases for the exam. I mean, it's a 50-question multiple guess exam, and it's a big picture case. So don't worry about knowing individual cases. But in that case, the court did say that Congress had exceeded its authority by attempting to pass the Violence Against Women Act under the Commerce Clause because violence was not commerce. So that's been a little bit of a reversal again more recently. Due Process Clause, important clause in the U.S. Constitution. There's a due process clause in both the 5th and the 14th Amendment to the U.S. Constitution. The 5th Amendment due process clause says the government may not deprive a citizen of life, liberty, or property without due process of law. So that's, again, fairly broad language. The 14th Amendment then extended the due process clause to the states, saying that the states couldn't do that either. And so what is due process? Generally speaking, due process is notice and an opportunity to be heard. So if there's some kind of a trial or some kind of tribunal or some kind of decision maker who is fair and unbiased and you get notice that there's going to be a hearing to give you an opportunity to complain about the action or to get compensation for yourself from the action of the government in depriving you with life, liberty, or property, and then you get an opportunity at that hearing or tribunal that you had notice of to be heard, then under those circumstances the government can deprive you of life, liberty, or property. Now obviously we have a sliding scale here. The protections that are in place for the government depriving you of your life, which would be in a death penalty type situation, are extensive. You'd have to be convicted by a jury of 12 people at a trial. You'd have to then have your ability to appeal, all of those things, all the way up to the Supreme Court. And there are great protections that would involve that. Now, if this is a situation where the government, the local government, is deciding to put a utility line through your front yard, probably you're looking at a hearing in front of some citizen board, zoning authority or something like that, or utility authority, and you'll get the opportunity to complain about it, but probably as long as they follow their rules, they're going to get to place that utility line, and you're going to be stuck with some kind of payment by the government to sort of compensate you for your inconvenience and your loss in that situation. All right, moving on to the Equal Protection Clause, which is contained in the 14th Amendment. That says that no state shall deny any person within its jurisdiction the equal protection of the laws. That is designed to prevent the citizens of one state from enacting rules and laws that protect their citizens at the expense of the citizens of another state. And if I recall correctly, maybe in your book or reading materials, there was a case where maybe the state of Michigan had enacted some rules relating to production of wine that was favorable to their wineries and caused some burden or additional burden to other states. That would not be appropriate. Where it's equal protection is really applied most frequently, however, is in the situation relating to laws and rules that would discriminate against people based upon race or religion or some other characteristic. Now, it is possible for a state or local government or the federal government to pass a law that does apply certain classifications. However, those would have to be rationally based. So, for example, if you are running a fire department and you have a requirement that the people that are going to be fire persons are going to need to be able to lift a certain amount of weight or run a certain speed in a dash carrying something, as long as those are rationally related to the job, then the fact that those might have a discriminatory impact on women or others would not necessarily mean that they would be unconstitutional. However, generally speaking, whenever we have any kind of a classification relating to race, national origin, or religion, those are invalid per se under equal protection. Privileges and immunities similar to equal protection. Again, can't go into another state or make a rule in one state that prevents other people from the other state from doing business. And most of our protections that we have, we will find in the Bill of Rights. The Bill of Rights is the original first amendments that were passed after the ratification of the Constitution. All right, moving on to sources and authority to regulate competition and prices. We already talked about the number one way that the federal government regulates commerce, and that is through the Commerce Clause. They are empowered through the Commerce Clause to regulate trade amongst the several states with foreign nations, with Indian tribes. In addition to that, we talked about some of the laws that had been passed over the years to try to regulate business. The Sherman Antitrust Act and the Clayton Act would be the two that I would be most familiar with probably for the exam. However, Robertson-Patman and the Federal Trade Commission Act are some other ones that we did talk about. States also can regulate commerce. The authority for that usually is derived from what's called their police power. You may think of police power, probably would think of police power, most people would, as the power to have a police department. but actually the police power, as it's been defined historically, is the right of a government to regulate the health, safety, welfare, and morals of their citizens. And so if there's a business that's in some way impacting the health, safety, and welfare of the local folks there, then the states would also have the ability to come in under their police power and regulate those. Of course, this is all subject to the possibility that that has been preempted by federal action. Of course, that still applies, but if it's not something that has been preempted by the federal government or isn't reserved to their particular area or sphere of influence, then the states would have that power as well. All right, Sherman Antitrust Act. Why is it called an antitrust act? We don't think of trust so much now the way they thought about trust at the time that that act was passed. Nowadays, trusts are something that we might establish to put money in a fund for someone to go to college, or to perhaps help some person that was not capable of managing their own affairs, or to save money for a minor until they became of a certain age. But back in the bad old days, trusts were the #1 form of business combination. So these trusts would own these various businesses, and at that time there had been an economic downturn, and there was a general feeling that these trusts and their greed and expansion had been at the root of that economic downturn, and so there was a big push to regulate these particular entities. So what does the Sherman Antitrust Act says, or what does it say rather? Section 1 says every contract combination in the form of trust or otherwise. So it doesn't have to be a trust. It can be a corporation, limited liability company, sole proprietorship. So any combination, or conspiracy. That can just be an agreement between any two businesses or individuals, which is in restraint of trade or commerce among the several states or with foreign nations, is declared to be illegal. So that's fairly broad language there. And then in Section 2 of Sherman, it goes on to say that every person who shall monopolize or attempt to monopolize or combine or conspire with any other persons or persons to monopolize any part of the trade or commerce among the several states or with foreign nations shall be deemed guilty of a felony. Back in those days, the mantra was the more competitors that we had that were working hard to try to be the best, then the consumer benefited the greatest. You know, it kept competition, kept prices low, kept driving innovation and things like that. I think we've maybe seen a little bit of a lessening of that as businesses have become larger and more combinations of businesses have been allowed. And there may be some good reasons for that, frankly, particularly as it relates to international trade. But things were different back at that time. All right. The Sherman Act prohibits any act which would tend to create a monopoly. However, it doesn't apply necessarily to every business. It only applies to businesses with what's called market power. So the Federal Trade Commission or the federal government is not going to go out there every time that one convenience store buys the one next door, or a gas station owner acquires the one across the street. That's not necessarily going to be a situation where the government's going to get involved. However, if that combination, even a combination that's small, creates the ability to control price and exclude competitors in some particular geographic area, it may be something that would be subject to that type of scrutiny. I mean, we think about large mergers like Time Warner with AT&T and some of the fears that was going to reduce competition and things like that at a national level. But if you are in a community, I suppose, and there's only one grocery store, or there are only two grocery stores rather, and they're going to combine with one another, then in that particular geographic area, that may be something that could be considered to be violative of the law. It is not designed to punish businesses for being successful. What it is designed to do is to keep those businesses from using that success and that market power to keep others out, to exclude others from the market. All right, horizontal mergers. So mergers at the same level, meaning competitors. Mergers of competitors was one of the first smart ways that businesses decided to try to get around the Sherman Act. because they couldn't make a deal with their competitor to fix prices or to agree to only pay so much for the natural resources that they needed for their business. They would just buy their competitor, and then they weren't making an agreement with anyone else, they were making an agreement with themselves. And so therefore the Sherman Act would not apply. However, the Clayton Act was passed in part to address that issue, and so mergers and acquisitions are prohibited that do substantially lessen competition. Very frequently you'll see the federal government weigh in on a proposed merger, and that's because the businesses that are proposing that merger have asked the federal government to weigh in. They want to know whether or not the federal government will move in if that merger takes place and attempt to block it or to require that it be unwound after the merger has taken place. Obviously that would be a very expensive process, and so most businesses want to know what the position of the federal government is in advance. They're glad to give that to you, and very frequently when they do not approve a merger, then the parties decide that now is not the right time to enter into that. All right. Vertical price discrimination. That's charging different prices to different buyers of things that are the same, like grade and quality. That is illegal if it tends to reduce competition or create a monopoly. So you can't sell your goods to Walmart a lot cheaper than you sell them to mom and pop if you are a wholesaler. That's the theory. Things that are included in the price, by the way, bonuses, incentives, and free advertising. So if there's some advertising or something that goes along with it, that's got to be factored in. You can't say, well, we're charging a different, or we're charging the same price, but throw in for Walmart all these perks and things like that. So you got to add everything up in determining what the price is. Also, selling below cost is illegal if the effect is harmful to competition. That might be, you might think of that as dumping. So you've got a lot of a particular product and you just want to get rid of it, and so you decide to sell it below cost. If that is harmful to competition because you're selling at a discount to one competitor, not to everybody, then that could be a violation of the law. However, you can sell below cost if you're matching a competitor's price. Other limitations, you can select who you do business with still. However, you cannot do that if the purpose for only doing business with one particular person along the supply chain is for the purpose of restraining trade. You can't enter into exclusive dealing arrangements with individuals up and down the supply chain. Might think of that specifically as, for example, or one of the ways why that might be allowed is if there are inter-brand competition such that intra-brand competition may be lessened. So these are one of the ways why when it would be okay. So example of that might be, let's say Edward Jones runs an investment business, and Edward Jones is going to give an exclusive territory to someone, and that is West Lafayette, Indiana, for example. That is in restraint of trade, right? It would be more fair, theoretically, if they would just say, we'll pay anybody that is interested in selling securities under the Edward Jones name this much money a year. How many takers do we have? We might have 50. But of course, that's going to make it difficult for the individuals to make any money. Probably would guarantee that no one would make any money. So it's okay for them to enter into an exclusive dealing agreement with one person in a particular territory. The theory is that even though there's no competition for that particular brand, for the Edward Jones office in West Lafayette, Indiana, there are inter-brand competitors. Northwestern Mutual may have a particular office in that town. Raymond James, Charles Schwab. So because of those, it's okay. A similar situation might be with Coke and Pepsi. It's okay for a restaurant to just be Coke or just Pepsi, or for Coke to say this is our exclusive bottler and distributor, and Pepsi to say this is our exclusive bottler and distributor, because the competition between Coke and Pepsi is what is important there. Suggested retail prices, you see those on packages, a lot. Those are okay, even though they have the potential effect of fixing prices, which would lessen competition. As long as those are only suggestions and there's no enforcement of those prices, then suggested retail prices are okay. Another thing illegal is something called tying. Tying is where you make people buy a less desirable product in order to get the right to purchase the nicer product that everybody wants. So tying, again, is considered to be a restraint of trade. It is illegal, violates the Sherman Act. The example that's been many years ago now was originally Microsoft would require anyone that bought Windows to also buy Internet Explorer. And the theory of that was the people that sued were, I think, Netscape Navigator or something that doesn't exist. So you can see it was a very successful strategy by Microsoft, even though they were sued and lost in court, to tie the purchase of this Internet Explorer to the purchase of their Windows product. So that was deemed to be illegal, but apparently was effective. Remedies. What happens if you do engage in anti-competitive behavior? There can be criminal penalties for engaging in this behavior. For a corporation, up to a $100 million fine. For an individual, up to $1 million fine and 10 years in prison. Can't put corporation in prison, but as an individual, you could go to prison. There are also civil penalties. The court could enter an injunction and tell you just to stop doing what you're doing. There could also be what's called treble damages. So what treble damages would be is if you engage in anti-competitive behavior, the individual that was harmed by that would then have the responsibility, either through the government or through their own attorney, to prove how they were damaged or in what amount. And then, because this is a situation where we're not just trying to compensate those individuals, we're also trying to punish the person who did it and to hopefully discourage others from doing it in the future. Not only would you have to pay the actual amount that they lost, but 3 times that amount, which is where the term treble damages comes from. Class actions, the anti-competitive behavior can be addressed through states' attorneys general who would sue on behalf of businesses or consumers that were harmed in their particular state. All right, let's move on to administrative agencies. We spoke a little bit, even in this review, about them already, and of course we talked about them in class. Administrative agencies are created by Congress, so there has to be an enabling statute that creates these Congress to address a particular issue that Congress has decided is important at that particular time. So we might think recently, the Department of Homeland Security, right? There were terrorist attacks. Congress became concerned about this. We established the Department of Homeland Security. Back in the 60s and 70s, there was great concern about pollution and the impact of pollution on the health, safety, and welfare of the citizens. The Environmental Protection Agency enabling legislation was enacted at that time. So some examples, it's kind of an alphabet soup there. Federal Trade Commission, EPA, which would be Environmental Protection Agency, Federal Housing Authority, Food and Drug Administration, ATF is the Bureau of Alcohol, Tobacco, and Firearms. So those are some examples. States also have administrative agencies, and the state legislatures would create those agencies with enabling legislation. Here in Indiana, we have the Indiana Department of Environmental Management, the Bureau of Motor Vehicles, and the Indiana Utility Regulatory Commission. And again, those are just some examples. There are many, many more out there in addition to those. Administrative agencies are unique. They're unique, first of all, in that they are headed by appointed and not elected administrators. The leader or the head of the Environmental Protection Agency is appointed by the president. The government, the Senate, the legislature may get an opportunity to give a thumbs up or a thumbs down on these appointments, but they are not directly elected by the people the way that the president or the mayor or the city council or the Congress or the Senate is. Also, unlike the other 3 branches of government, and really the administrative agencies almost act like a 4th branch of government, administrative agencies combine the judicial, the legislative, and the executive functions all sort of under one roof through their structure. They are, however, required to operate in the open. So the theory is that even though these unelected individuals are exercising all of this power, including the power to make statutes and enforce them and police them, that they are required to do so in the open and are therefore subject to scrutiny. The things that you may want to know for the exam, or remember, the open records requirement is under the Freedom of Information Act. So under the Freedom of Information Act, all of the administrative agencies' records have to be open. Under the Sunshine Act of 1976, their meetings have to be open to the public and subject to scrutiny. And they have to publish all of their proposed rules, principles, and guidelines for public review prior to them becoming the law. So, how do they enact laws? The laws that agencies enact can have a devastating impact on people: criminal penalties, civil penalties, huge fines, but generally speaking, as long as they act within the scope of their enabling legislation, then courts will uphold their exercise of that power as a legitimate exercise of governmental power, and will even allow rational expansion. So, for example, the FCC, the Federal Communications Commission, was established long before anyone ever probably dreamed of smartphones or cell phones. But Congress and the courts, rather, have agreed that the FCC can regulate cell phones because that is the rational expansion of their authority from the authority that was originally granted by Congress to probably regulate the telegraph, right? So the cell phone is the descendant of the telegraph, if you will. All right. How do we get an administrative rule or regulation? This is obviously a broad brush course, and so this is a very general explanation of the process. But first, again, the agency has to be created by Congress, and it has to be acting within the scope of that enabling legislation that created the agency. The agency would then research the issue involved in the potential rule, and it would issue what's called a proposed regulation. That would be then published for scrutiny. So it would be published in trade publications, be published on the website, and it would give people an opportunity to consider whether this proposed rule or regulation was a good thing. The normal comment period would be 30 days. If after the comment period the agency decides it's still a good idea, then they can adopt the regulation. They could withdraw it if they decide it's a bad idea, or if after the comment period they get some good comments and they decide that there may need to be a modification to it, they can modify it. If that modification is substantial enough, then they're going to have to do a new comment period, right? I mean, if it really changes the nature of the regulation significantly, they're going to have to do a new 30-day comment period, and the process starts over. So that's how the legislative power is exercised by the agency. They make rules which have the force of law. How does an agency exercise the executive power? They have the ability to investigate violations of their rules and regulations. They have their own investigators that go in. They can issue subpoenas to people and require them to come in and testify or to produce evidence that they would want to look at. Of course, that is not an unlimited right, just like the police department and the Congress. Businesses and individuals do have Fourth Amendment rights against unreasonable searches and seizures. And so that may require that the agency get a warrant from a court before they can act. However, records are something that they can almost always get. So they can usually request those without a warrant with a subpoena and get those. You don't have any right against self-incrimination of the business, basically. So you may have done something criminal and you couldn't be compelled to testify against yourself in a way that would tend to incriminate you of that crime. However, if there are business records that are in the presence of the business or in the possession of the business that show that you committed the crime, you don't have a Fifth Amendment right to say, no, I'm not going to turn over those documents. Those are subject to subpoena. Also, routine inspections, so OSHA, for example, Occupational Health Safety Administration, does come in periodically and inspect workplaces, including probably this workplace, to make sure that everything is in compliance. So that's how they exercise the executive power. They essentially run their own investigation and police force. In addition to that, administrative agencies can function as courts, in a sense. If they find a violation, they do maintain a court-like system that is tasked with determining whether there should be a penalty for that, or determining if there is a violation and what the penalty should be. You can have a proceeding filed in one of these administrative courts, filed by the agency itself or by a competitor or some other individual that feels that they were wronged or that you have acted in violation of these agency's rules. The judicial system hears the evidence, or the agency's judicial system hears the evidence. They can dismiss the action, or they can direct that there be some remedy. In other words, you violated the rule, you pay this much to the other party. It is true that the due process rules, the due process clause of the 5th and 14th Amendment, do prevent the government from depriving you of life, liberty, or property without due process of law, as I mentioned. And obviously, if you get a fine, that's depriving you of property. So you are required under these administrative proceedings to have notice and a hearing. Now, as a practical matter, sometimes that doesn't happen, but that doesn't necessarily not happen for bad reasons. Frequently, the administrative agency will simply issue a penalty. They'll say, we haven't had a trial on this yet, so we haven't, I guess, heard all the evidence, but here's what we believe the situation is, and this is the fine that we're going to impose upon you. And very frequently, the parties that receive that fine decide, you know, if we go to have a trial, it's not going to get any better than this. In fact, it could get worse, so we'll just go ahead and accept this sort of initial ruling of the agency without going through the trial process. No jury trials in administrative proceedings. An administrative law judge appointed by the executive branch would hear the case. Generally, there's not a rules of evidence are not enforced in those agency proceedings. They tend to be fairly informal. All the ones I went to, the judges were sitting in golf shirts and khakis, so it's certainly not the same as a trial in my court. So what if there is a violation found? The decisions of agencies are binding on the individuals involved. However, you do still have a right to appeal to the court system, the real court system, as I would say. That the administrative law judge would have cringed as I said that, of course. But you do have a right to appeal a final judgment of an administrative agency to the court system. But that administrative agency can do all the things a court can do. It can issue fines, it can issue cease and desist orders, which are like injunctions, stop doing this and don't do it in the future, is what they do. If you are going to go to the court system, the real court system, to appeal what happened at the administrative level, you have to do what's called exhaustion of all administrative remedies. So you can't just get a bad result sort of early on in the administrative process and jump right to the court. You have to go through all of the processes to get a final ruling from that agency, and then you can move on to the next level. And there are some exceptions to that. And there they are, administrative process isn't going to provide relief. Irreparable harm is going to result if you make me go through all these stages before I can get my relief, or an appeal to the agency would be useless. Those are pretty narrowly tailored exceptions, and so generally speaking, you want to go through the full panoply of administrative rulings before jumping to the court, because if you get to the court before doing that, the court may well say that this claim isn't ripe for review because you haven't gone through all of those steps, and send you back down to the agency level, which would be expensive and unnecessary. All right. Moving on, let's talk about crimes. Victims of crimes may be people. However, the initiating party, as we mentioned earlier, in a criminal case is the government. And so the parties in interest in a criminal case are the federal government or the state government and the defendant. Now, the federal government or the state government may be acting because Bill Smith was murdered or Cindy Sue was robbed. However, and they may be the victims of the crime. However, it is not the victim of the crime that drives the case. That's a frequent misconception that people have a lot of times in cases where there's been a fight, between two people and somebody gets criminally charged, and then the person that was the victim of the fight says, I just don't want to press charges. Well, the bad news for them, I suppose, and for the defendant, is they're not pressing the charges. It's the state or the federal government. And so while the state or federal government may take that opinion into consideration in deciding whether to proceed, it is the decision of the federal or state government that is final in that situation. All right. Punishment for crimes, of course, can potentially include fines, big fines, but the real distinction between crimes and civil wrongs, which are torts, which we talk about in the next chapter, is that there is the possibility that you may lose your liberty, you may be imprisoned, in addition to fines and costs, and potentially even be executed, right, depending upon the situation. In a criminal case, the proof that is required is proof beyond a reasonable doubt. So that's the highest standard of proof in any case. So whenever we have a criminal case, the defense lawyers particularly like to talk to the jury and say there are different standards in the law, and so a preponderance of the evidence is the standard that would be required in a civil tort case, and so that just means what's more likely than not. And just think of the terrible consequences that could potentially flow. If you were found to be responsible in a civil case, meaning the scales just barely tipped, you could lose all of your worldly possessions, all of your assets, if you were sued and lost that kind of a case. And then they go on and say a little bit more strong presumption or a little bit higher burden is the requirement that the case be proved by clear and convincing evidence. And a case like that would be if they were going to take your children. The government was going to come in and declare you to be an unfit parent and take your children away. They'd have to prove that by clear and convincing evidence, and aren't your children the most important things to you in the world? And then the defense attorney will tell the jury, and correctly so, this burden is even higher than that. They have to prove beyond a reasonable doubt that this crime has been committed, sort of in an attempt to make it almost seem like an impossible prospect for the state to meet that particular burden. All right, types of criminal laws. Misdemeanors are the least serious criminal offenses. They are punishable by up to a year in prison. Felonies are punishable by over a year in prison. There's also murder. Murder is a felony, but it is also murder. In Indiana, that's its own separate classification. Crimes can be felonies in one state and misdemeanors in another state, and crimes can be felonies one year and misdemeanors the next. There are a lot of drug crimes that recently were decriminalized that were felonies for many, many years, and then suddenly the legislature changed their mind and they became misdemeanors. So crimes can be punished differently in different places. There are also some types of cases that are prosecuted by the state but which aren't actually crimes. They're actually civil cases. Those would be, an example would be infractions. A speeding ticket is, you can't go to jail for a speeding ticket. Littering is a civil infraction, right? You can't go to jail for littering. Now, if you're speeding and you're driving recklessly as you're speeding and you cause an accident that kills someone, that can be a crime, right? Or if you're littering and you throw a cigarette butt out the window and it causes a forest fire that kills a bunch of people, that can potentially be a crime. But just those minor things, generally speaking, those are civil cases. Proof is not beyond a reasonable doubt for infraction violations. It would just be by a preponderance of the evidence in those situations. All right. General criminal law concepts. Generally speaking, the government has to prove some kind of act or failure to act before there is a conviction for a crime. Right? There are very few things where a failure to do anything would be a crime, but there are some. Most cases, it's actually an act that has to be proven. You also have to have been shown to have a criminal state of mind. That is a concept called mens rea. The idea there is that we don't want people being convicted of crimes because they accidentally did something. Just made a slight mistake in judgment. So if we're driving down the road and we miss a stop sign and we slam into a car and some people are killed. Most generally speaking, that's not going to be a crime. It may be a civil infraction. You may be sued for careless driving, but in most cases that would not be a criminal offense. The idea being that the level of culpability, of guilty thought, of intention simply doesn't come up to the level that would require that. Now, if you were drunk when you did that, even though you didn't intend that accident, you intended to drink and you intended to get behind the wheel of the car, that would be enough of a guilty mind to satisfy mens rea, meaning that probably would be a crime, or it would certainly be a crime in all 50 states. So you have to have some intent to commit a crime, generally speaking, before you can be found guilty of a crime. You're not going to be found guilty of criminal conduct just based on an accident or something like that. The terms in Indiana for the guilty state is, that, generally speaking, is that you have recklessly, knowingly, or intentionally engaged in this conduct that was a crime. Another criminal concept that we hear a lot about is conspiracy. A conspiracy is an agreement between two or more persons to commit a crime. In most cases, it also requires what's called a substantial step. So if you and your buddy are sitting at Harry's and you're talking about knocking off the bank, generally speaking, that's not going to be a crime. But if you take some substantial step towards the commission of that crime, let's say after that agreement, one of you goes out and gets the specifications for the layout of the bank vault from the internet, or goes and starts casing the joint and looking and seeing when the Brinks truck comes and goes and things like that. That would probably be enough to get you in trouble for conspiracy to commit that crime. Conspiracies, incidentally, are generally punished at the same level as the crime itself. So a conspiracy to commit bank robbery, generally speaking, has the same potential penalties as the bank robbery itself. So whether you go through with it or not may not make a difference. Money laundering is a popular crime, I suppose, and one that impacts businesses in some situations. Money laundering is where we use a legitimate business to funnel the proceeds from an illegitimate business. Why would we do this? Any of you who have watched Breaking Bad understand money laundering perfectly well. You have money that you've gained through selling drugs or prostitution or some other illegal means. You'd like to be able to spend that money because that's one of the benefits of having money, is the ability to spend it. But if you're out there spending money and the government takes notice, and they will, particularly if you put that money in a bank or spend it on anything that's in any way regulated by the government, they'll wonder where that money came from. If you can't show where that money came from, you might be in trouble for tax evasion or whatever. So you find a business that is a cash business. In the Breaking Bad show, it was a car wash business, but very frequently it's something like a restaurant bar or a strip club, or used to be vending machine routes, casinos, where it's really hard to keep track of how much money is coming in and coming out because so much cash is changing hands. And then you just have a really profitable, legitimate business. You declare those profits, you pay taxes on those profits, and therefore then you can spend that money without being concerned that it's going to raise too many red flags with the government. There's a new Netflix series called Ozark, which I've only watched one episode of so far, but it supposedly involves a financial planner that was involved in a money laundering scheme, which makes no sense, because if you had dirty money, why would you bring it to one of the most highly regulated fiscal industries in the world, which is financial services? Everything has to be reported, every transaction is recorded, so it would not make sense, in my opinion, to use a stockbroker to launder your money. You would definitely want to stick with the standard casino, vending machine route, car wash, strip bar type of situation. Banks are required to report sizable transactions. 10,000, I believe, is where we are now. So if you deposit or withdraw 10,000 or more, the government is getting a notice of that, and they may choose to look into that and determine what the source of those monies are. All right, another criminal law that impacts business of recent vintage is the Sarbanes-Oxley Act. It was passed in response to corporate scandals. It provides significant fines and jail time for altering and destroying evidence. Sarbanes-Oxley was passed in response to the Enron scandal and some of the things that came along with that. I'm not sure if you're familiar with that, but there were creative accounting that was done to hide losses that businesses were having, which allowed the stock price of that business to go up, up, and up because they were always meeting or exceeding Wall Street expectations. The owners of those businesses were involved in that and actively participated in hiding losses and misstating the financial position of the company. They would, of course, benefit from that because their compensation in part was based upon the success of the stock. At some point then, the truth came out, the companies came crashing down. Most of the people that were responsible for it had already cashed out their stocks at that point, so they locked in their profits at the expense of pensioners and others who lost everything. So Sarbanes-Oxley was passed. Back in those days, documents were shredded. Nowadays, with electronic documents, that's a little bit more problematic. But there are significant criminal penalties for accounting firms like Arthur Andersen, who was involved in Enron. Arthur Andersen actually ceased to exist as a result of the Enron scandal, and they were, at the time, one of the preeminent accounting firms in the world. So officers and directors who sign financial statements, either your quarterly or your annual statements, are required to certify that they are accurate. You can't simply use the Ken Lay at Enron excuse that, well, golly gee, I'm not really a numbers guy. I'm more of a big picture guy, and I didn't know, but I signed them anyway. You are required to certify that they are accurate, and if they turn out to not be accurate and there's a loss as a result of that, you can be jailed or pay huge fines. All right, procedural rights of individuals and businesses under criminal law. The Fourth Amendment provides that we shall be free from unreasonable searches or seizures. The Fourth Amendment was passed because, of course, in reaction to the fact that the individuals here in America felt that when the king wanted to prosecute them for something, that the brute squad would simply come in and kick the door down and rummage through your things until they found what they wanted. And people wanted to have privacy in their homes and businesses. So now, before the brute squad come in, kick down your door, and rummage through your things until they find what they want, they've got to get a warrant. They've got to go before a judge or a detached magistrate. Detached meaning that they don't have any interest in what's going on. They don't have a reason to be biased. Then they have to prove to that judge or detached magistrate that there is probable cause to believe that there's evidence of a crime or the fruits of a crime or contraband located at that particular location. If that is proven to the judge, that there is probable cause to believe that, there will be a warrant issued. That warrant is supposed to describe with particularity what they're searching for and where they're allowed to search for it at. And so if the warrant is for a rifle, they can't search in little drawers in the bureau where a rifle could not be found. Now, if it is to search for drugs can be in very small quantities, and that would essentially be a carte blanche to search everywhere, but not the case for a larger thing. There are some exceptions that do allow the government, acting through the police, to seize your things without getting a warrant. And the two most popular of those would be exigent circumstances, meaning if we didn't go in without a warrant, the things would have been destroyed. So the police have probable cause to believe that there's cocaine in the residence, and before they can get a warrant, they hear commotion and frequent toilet flushing, suggesting that the cocaine is being flushed down the toilet. That would be potentially exigent circumstances. They might break in and seize the cocaine, and so even at that point without a warrant, that might be okay. Plain view, if you leave something out where the police can see it from a place that they have a legal right to be, they don't have to go get a warrant before they seize it. They can simply seize it. So if you let them in your house and there are a bunch of drugs on the table, that are clearly contraband. They don't have to wait for a warrant. They can just seize those at that point. If you're growing a marijuana plant in your front yard that everyone can see, they don't need to go get a warrant before they come in and hack that down and take you off to jail. Another right is attorney-client privilege. Attorney-client privilege protects all communications with counsel. So if you are a person charged with a crime and you have private conversations with your lawyer, the state can't then bring your lawyer into court and make your lawyer tell them everything that you said, obviously. There's also the Fifth Amendment right to remain silent. You can't be forced to make any statements that would tend to incriminate you. But remember that since business records belong to the business and not to you, that if you've committed a crime and it's reflected in the business records, you don't have attorney-client privilege there. You probably don't have attorney-client privilege with regard to the business's lawyer as opposed to your individual lawyer. So proceed with caution, or don't commit crimes, which is even better. Fifth Amendment right, again, to due process applies to both individuals and to corporations. You cannot be deprived of your life, liberty, and property without due process of law. All right, moving on to torts. Torts, derived from the Latin word meaning tortus, which is crooked, dubious, or twisted. They are civil wrongs, a violation of a private duty, but not crimes. An act or omission can be a crime and a tort. So there is a tort of battery that you would have to prove in a civil context to receive money or compensation because someone had hit you and hurt you. There's also a crime of battery that might be prosecuted separately by the state. How are crimes and torts differently? As we mentioned, in a crime, the government brings the prosecution. In a tort, it's the injured or wrong party. Burden of proof is different. In a criminal case, beyond a reasonable doubt. In a civil case, just by a preponderance of the evidence, which is the lowest. Also, the penalties are different. Fine, restitution, jail, death for a crime. For a tort, the only potential remedies would be money damages or injunction, which was the judge saying stop doing that. Different classifications of torts. We have our intentional torts. We have our negligence and strict liability offenses. So the intentional torts, we'll go through those. Assault is the first intentional tort. Battery, false imprisonment, intentional infliction of emotional distress, invasion of privacy, defamation, product disparagement, and wrongful interference with contracts. We've gone through all those. Oh, and trespass. So we went through all those in class previously. I'm going to go through a few of them in a little bit more detail, and you can derive from that what you will with regard to what's important for the exam. Invasion of privacy. In criminal law, invasion of privacy is a violation of a court's protective order. So if someone's got an order of protection and someone goes in and contacts them in violation of that. However, invasion of privacy in the tort world has three subsets. Intrusion into someone's private affairs, placing a camera or a drone or something into some private location and making recordings would be examples of that. Public disclosure of private facts, getting a hold of someone's medical records illegally and publishing those or making those available to other people, or private business records. And then finally, the third subset of the tort of invasion of privacy would be appropriation of another's name, likeness, or image for commercial advantage. So someone uses a picture of George Clooney in an ad for their timeshare, sort of suggesting that George Clooney lives in this complex and that you're likely to meet George Clooney and probably hang out with him if you go there. Unless you've paid George Clooney for the right to use his image, that would be a tort of invasion of privacy. Defamation, another fun tort. Under the tort of defamation, there would be an untrue statement about another person's reputation, honesty, or character. Publication of those statements. Publication doesn't mean you put it in the paper. It means any communication of it. Send it in a text message. Tell someone verbally about that information. Send it in a letter. Say it on television. Those kind of things. And then damages. So untrue statements involving reputation, honesty, or character, publication of those, and then that person suffers in some way as a result of those. That would make for the crime of defamation. Verbal defamation is called slander, and written or broadcast defamation is called libel. Truth is a defense to slander or libel. So if you can say, this is true, then you may be able to avoid liability. Now, if the defamation was also a violation, let's say of HIPAA, Health Insurance Portability and Privacy Act, you may be subject to some kind of fine or penalty under that particular statute, but it could be a defense to a slander or libel. There are certain privileges or certain persons who are privileged to say things and not to be concerned if they're going to be sued under a defamation suit for libel or slander. One of those groups is congresspersons speaking on the floor of the House or Senate. Anyone who's ever watched C-SPAN for any period of time sees the absolutely knuckleheaded things that our elected representatives say. It's an embarrassment to them and to everybody else. But there are certain people in our country for whom that apparently is attractive. And one of the reasons they can say what they want is because they are immune from libel or slander claims while speaking on the floor of the House or Senate. If you are a witness and you're testifying under a grant of immunity, meaning you can't say, I'm not going to testify because I don't want to be sued or criminally prosecuted, as long as you have been granted immunity from criminal prosecution or civil prosecution, then you can go ahead and say what you want to say on the stand. The media also has a qualified privilege for not having to worry about being liable for defamation, slander, or libel for the things that they print, so long as if the things that they say or print are later found to be false, they issue a retraction, and so long as at the time that they made those false statements, they didn't know that they were false or make them with the intent to hurt the person. So they can innocently make statements that later turn out to be false as long as they make a timely retraction and not have to worry about being sued. Wrongful interference with contracts, the elements of that tort are intentionally causing a person to break an existing contract and there being damages that occur as a result of that. How might this come up in your world? All of you are going to have jobs. You may have coworkers that you like, and you may not like your boss. You, as a result, may decide to go and work somewhere else. If in the course of doing that, you talk your coworker that you like, who is under contract with your boss, to come with you, you may be held liable for wrongful interference with contracts and sued, and in some cases successfully as a result, so be cautious when you're doing that. All right, moving on to negligence. Negligence is the most frequent source of tort litigation. Negligent conduct may also be a crime, an intentional tort. So a battery that occurs may be an act of negligence, may also be the intentional tort of battery, may also be the crime of battery. Negligence exists whenever there is a duty that exists between people. And generally speaking, all of us have some kind of a duty to exercise reasonable care as we interact with one another. Walking down the street, driving a car, doing any of those things. There is a heightened duty that is owed between professionals and their clients. So for example, a lawyer has a duty to use reasonable care in exercising their judgment as a lawyer. And if you fail to do that, you would be guilty of malpractice, which is a subset of negligence. If you're driving your car, you have a duty of reasonable care to operate it that you owe to everybody else that's around the road. If you fail to exercise that duty, then you may have breached that duty. So you have to have the duty, you have to have a breach of the duty, and some damages have to be caused as a result of that duty. If those elements exist, then the tort of negligence is proven and a court can step in. The damages have to be directly or proximately caused by the breach of the duty and a foreseeable result of that. And that can be a little bit of a difficult thing. There's a famous case relating to an individual that picked up a parcel on a train platform and ran after, I think, the train and attempted to get the parcel to the person on the train or something like that. As a result of that, unbeknownst to the person that was doing this, I think the parcel may have had fireworks in it, and there was some terrible accident, and people were hurt and maybe killed. But in that situation, that court held that while the acts of this individual in trying to do this were negligent, they were not done in the exercise of reasonable care, that these damages that had occurred as a result of this were not the foreseeable result of that, so therefore that person would not have been required to pay for those damages. Defenses to negligence. Contributory negligence is the traditional defense to negligence. So if you are sued for negligently causing a damage to someone else, under that defense, if you could show that the other person, the injured person, in any way contributed toward their own injury by their own carelessness, then it would bar all recovery against you. That theory proved to be fairly harsh in its operation, and so nowadays we have a theory that's more broadly used called comparative negligence, and under a comparative negligence theory, the jury or the judge is required to apportion fault for causing the injuries between the plaintiff and the defendant. And so long as the plaintiff, the person who was injured, so long as their fault is less than 50% of the total cause, then the defendant is still required to pay. Now, if it's determined that the plaintiff is 25% the cause of his or her injuries and the defendant is 75%, the amount that the defendant is required to pay is reduced by that 25%. So there's a reduction to 50%, and then if it's determined that the plaintiff is more than 50% liable, then there would be no recovery at all. Under a strict liability regime, strict liability states or states that use laws that provide for strict liability, the theory there is all this litigation about who's at fault and apportioning fault and whether there was a proximate cause, all of this is cost time, it takes money. What we really need to do is just determine, was the person injured, did this product cause the injury, did this person's driving, and just dispense with the trial and just impose strict liability in some situations. Just make the plaintiff pay. And not go through this whole litigation process. There are few, if any, defenses that exist, primarily used in products liability situations and in California and places like that. However, there are defenses to probable, one of the defenses is assumption of the risk. So if you can show that a product was dangerous, the person knew it was dangerous, they nevertheless used the product knowing those dangers, then that could be a defense to liability, even in a strict liability situation. Okay, damages in tort cases. Compensatory damages are meant to compensate the injured person for the loss that resulted. They can include lost wages, medical bills, pain and suffering would be a compensatory damage as well. You can also, in certain circumstances, impose punitive damages. These are damages designed to punish the person that's committed the tort. Those punitive damages normally have to be authorized by statute and would only be available if the conduct was shown to be fraudulent, willful, malicious, or wanton. So in those situations, a court may award damages over and above what we're just giving to compensate the person, but also to punish the other side. So that's it. I know that's kind of a lot and went a little bit longer than I anticipated, but hopefully that'll be helpful to you in studying for the exam. Again, if you have questions, please feel free to call me or shoot me an email and I will answer them as best I can, and I will be in the class for the exam on Friday. Best of luck to you.